We are really excited to be here today. We're going to be discussing with Lawyer Jay Hait everything about, I hope I pronounced your name right actually, Jay, everything about inheritances and gifts and couples and money. Okay, so I'm Rifka Lebowitz, financial consultant, founder of Living Financially Smarter in Israel, and I'm really excited to be here. Jay.
Morning, everybody. My name is Jay Hait. I am an American Israeli attorney. I'm licensed in New York and here in Israel. And my Israel practice focuses solely on family law. Now, our offices are located, our main office is in Tel Aviv. And the way our office works is that all of my employees work either from their homes or in our Tel Aviv office, and I go around to the Anglo areas. Pre-corona, I was once a week in Jerusalem, once a week in Ra'anana, and then alternatively between Zichron Yaakov, Modi'in, and Haifa.
Okay, so Jay, I'd like to start with the law because it's very clear. I don't know if you saw or everybody saw, I posted a question yesterday on the Facebook group about a couple that got 700,000 shekel, and you know, they got divorced very quickly, and it was unbelievable watching the answers, seeing some people like, of course it belongs only to the husband, of course it belongs only to the wife, of course it belongs to both of them, of course it belongs to the parents. And it's very clear from that people do not know what the law is. So I'd like to just understand if you could explain the basis of the law in Israel, how it works with couples and money, if chas v'shalom, they were to get divorced or separated, because this is also couples who are not necessarily married. But before you answer, I just want to say that really, like when I teach personal finance or anything like that, I'm always saying, we go into a marriage hoping to have a great marriage. We're not looking to like try and be like, okay, well, if we get divorced, this and this happens. And yet there are times where we need to protect ourselves. So over to you, Jay.
Okay, so first of all, I want to make clear one thing, is that when you ask a question like that, people are reacting from two different ways. There's the moral response, and the moral response is that all the people are saying, my God, of course it should be the husband's. And then there's the legal response, and the legal response isn't always connected to the moral response, and the legal response has developed over the years for a number of reasons, either because of the court rulings or because of the law itself. But now let's look at your specific case, okay? So the general rule in Israel is that things that people accumulate during the course of their marriage are joint. In other words, any debts that you accumulate while you're married, any assets that you accumulate while you're married, they're joint. And therefore, on its face value, it would seem that, in fact, the wife would be entitled to half of the gift from the parents. Now, when there are challenges, one of the things that we look at as well, what was the intent? But always remember, when you try to guess what intent is after the fact, it's really hard, because I know myself as an attorney, you know, I can build the story based on the facts, and I know the other side can build the story also. And we're trying to say, well, no, what the intent was. So if I were representing the husband, I would say, you know, it's very clear that the intent was only that if we were married for a long time, I would probably look if there are emails, WhatsApps, things between the wife and the parents, etc. On the other hand, if I were representing the wife, it is incredibly clear that the law says, hey, we got this, it was commingled, right? In other words, they didn't keep it separate, it went into buying that house. So clearly, you know, it's something that was joint. And if he didn't intend that it would be my clients, the wife's, then they would have entered into an agreement, they would have put a lien against the property, they would have done something that says, hey, the intent is only under certain circumstances that you'll get this. Okay, so that's number one. And again, I'm specifically detaching it here from the moral position. Okay, that's not what I'm looking at as an attorney. I'm looking at the legal position. And by the way, as a legal position, if both people came to me, of course, you know, I would definitely prefer to represent the woman because I would have a much stronger case. then I would have represented the man in this particular fact scenario.
So just for anyone who didn't read it on Facebook on the group, the scenario was that couple got married. His parents gave them 700,000 shekel towards buying a house. They had not bought the house yet, and within a year of getting married, got divorced. And the woman was like, you know, half the money's mine. Just like you said, that's the law. Anything accumulated post-marriage belongs to both of them. So my question to you is, how we have people at different stages of life, okay? And probably listening to this, if I can group people, obviously there's more than just groups, but like we have couples starting out, like really beginning. We have couples who are happily married, totally trust each other, 10, 20, 30 years married. We have people looking into a second or third marriage. And we maybe have parents looking to gift their kids and want to be protected in case something happens. So let's just talk about the couples, let's say, starting out. Okay, if you were to advise a couple starting out, I know prenup is the word that's thrown around, have a prenup, but my understanding, and please correct, is that prenup is stuff that comes into the marriage from before the marriage, not what's accumulated together generally. So please explain a little bit about the prenup and how it can protect people and what else there is to protect people in this scenario.
Okay, so looking at newlywed couples, and I am asking you to remind me when I finish to talk about the Heskem Kavod Hadadi.
Okay, will do. Heskem Kavod Hadadi.
Okay, so, but in any case, look, every relationship is different. And really one of the things that I do a lot with people when they come to me about a prenup is talk about what it is that they want to achieve. Because the prenup between a couple who are coming in with 0-0, in other words, here, your typical Dati Leumi couple, okay? Dati Leumi people tend to get married younger, okay? So when they're coming in, they've got nothing. And again, in this scenario, I'm assuming that there isn't a parent on either side giving them a large lump sum gift for anything, okay? But so in those cases, it's usually, hey, you're coming in, then you should keep everything equal. And there I'm looking more to protect the interest to make sure that there isn't a situation with, how do you say, I mean, with one of the spouses being changed in the future. That's why I said to talk to me about the halakha prenup. But in any case, so there it's, you know, much easier. Hey, everything that we accumulate together will be together. And then I asked them, well, is one of you expecting a large inheritance, things like that? Then you might want to exclude it, you know, from the get-go. But otherwise, that's very different situation, and it's going to be a very different agreement than someone who comes in with a lot of money. And that's really the point where it gets harder. In other words, let's say you have A and B, who will be husband and wife, okay? And A, he's only 28, but by God, he had an exit, okay? So he's coming into the marriage with $4 or $5 million, and B is coming in with nothing, you know, but they love each other. And when they come to me, they say, both of them say, look, you know, the money that they had before, she doesn't want anything from it, okay? She understands that it's his and isn't looking. And then the question is, okay, that's at this stage of life, and I get it. But what happens when, you know, you both decide that either neither of you are going to work, or that A is just going to continue doing other high-tech things? And they say, hey, B, but B, you're going to stay home, you're going to bring up the kids, you're going to make sure I have a, you know, you'll be the balabustas that everyone will say, wow, what a household. Okay, well, then 20 years later, you decide for whatever reason to get divorced. Does B lose out? In other words, because B didn't go in during all of these years and develop a profession, because she didn't make money, because she stayed home with the kids, does it mean that she's SOL? You know, she's just stam out of luck? Can you guys, silence yourselves? I'm getting feedback from some of you.
I'm gonna see who's not muted. Yes, okay, muted.
So in any case, and that's a very different situation, and it's tailored each time, because in that type of situation, I would start asking these questions, and you know, usually I don't give them the answers. I throw some possibilities, but a possibility would be, and I'll give the case of someone that I did recently, where and it was exactly that case. And the husband just said, okay, you know, what I'm willing to do is to say, first of all, after each kid is born, there's going to be a certain amount of money that the wife will be entitled to if we get divorced. And I hated, schar b'yeladim. That's what my thought process was. On the other hand, I understood because what they were saying is, hey, she's going to be staying home with the kids to bring up the kids. Well, we want to make sure that if I just walk out, she'll have something. And the other thing that he did in that case was he put a lot of money into pension for her. He said, okay, I understand that you're not going to be working, you're not going to be accumulating pension. And what I'll do, and in that case, they agreed to put 12,000 shekels a month into a pension fund so that if they get married, that was kept as separate property for her. Okay, so that's, again, newlyweds where one person has a lot more different. But really the beauty of these agreements is that you can tailor it to any couple. Okay, I mean, what happens if you have two people, not a case where someone comes in with $4 million and some with nothing, but what happens if you have a case where, well, one person's coming in with $3 or $4 million and the other one has $20 million. So yeah, there's an inequality, but on the other hand, you know that both sides are going to be protected no matter what comes out. What do you do then? And these are the types of things that I encourage people to speak about. As a matter of fact, a lot of times when people come in and we start the process, and my employees say, well, Jay, why aren't we working on this or why aren't we working on that? And I tell them, listen, guys, because in the meetings that we've had, I've thrown up enough questions that they're taking a couple of months to go back and forth to find a place where they're going to be comfortable with each other. One of the things that I always tell people, and I'm sorry if I keep going on and on, but is that, people come to me a lot of times and they say, Jay, doing prenups is the most unromantic thing in the world. And I had somebody who, when she heard this, she first of all, I always say, yeah, really, guys, look at your ketubah. Your ketubah is really a prenup. So it's just that most of us don't understand Aramaic, so we don't know how much of a transaction it is. But more than that, I had someone come to me a while ago, and she said, Jay, you know what? I've changed my mind. I said, what? She said, I think the prenup that you pushed us and prodded us with questions about is the most romantic thing in the world. And I said, really? Why? Didn't it make it too transactional for you? And she said, no, because at the end of the day, I went home and I felt, oh my God, my husband to be is willing to put stuff down on paper to protect me. Okay, and for me, that was everything. I said, okay, great, I'm happy. I mean, I didn't look at it from that point of view, but I'm happy if it comes out to people that way.
Right, I hear that because I was going to say, just when you said that it was romantic, I was going to say something. It's like, it's so not romantic. Hey, we're going to share a life together. We want to, have kids together, build a life together, be totally vulnerable to each other, but I'm not willing to share money. Sounds horrible, right? But we're not really saying we're not really willing to share money. By doing this prenup or any sort of agreement where we're saying, look, if I do inherit 10 million, I actually want it in my name, and we'll discuss how to protect it. So we're actually saying, look, we just want to protect each other. And at some point in the marriage, there's such a level of trust and togetherness that we probably wouldn't want to protect the money from each other because really we're totally joined. I think a lot of this, tell me if you agree, is for cases where it's the beginning and we just don't know what's going to be. But couples that are happily married for 20 years, right? Am I right? Probably.
I would don't need say
this,
that.
But
one of the things that I've done with people is a lot of times is I ask them that question. I say to them, and especially let's not look at the big money cases. Let's look at your average upper middle class people, but someone's coming in with $700,000 or $800,000. And one of the questions I'll say to them is I'll say, hey, listen, I have a theoretical question that I'm just throwing out. Do you think that if you're together for 25 years, that at that point in time, you would want that? You would say, hey, that money should be shared, especially if you've been living on the fruits of it. And sometimes they'll say no, but usually they'll say, well, 25 years, yeah, that's a long time. And then I'll say, okay, well, we can also make in the agreement something that says after each certain amount of years, a certain percentage of your assets will be commingled. In other words, so you don't start on day one that everything's mixed, but after 5 years, you say, okay, 15 or 10 or 20% of our assets are going to be commingled, no matter who they're titled into. Okay. And now I know there are other attorneys who have said to me, oh, Jay, doing it that way is, can be problematic because at the end of the day, you're going to have everything evaluated. My answer is, so what? So I have to get an evaluation. You know, getting evaluations of stuff is a lot less expensive than litigating things. And if it gives the couple a firm foundation to start their life together, then I'm sure they'll rather that expense than the other one when the end of the year comes. Okay.
Right. And what advice would you give parents? Let's say the case that I posted yesterday.
So one last thing that I just have to add to people is that when you do a prenup in Israel, there are two ways of doing it. Okay. The first way is just go and sign in front of the notary public. And the other way is to have it affirmed as a judgment in front of a court. I always recommend to people to go and get it affirmed as a judgment in front of the court. And there are two reasons. So yes, it's a little bit more expensive, but it gives two very big advantages in my opinion. And the first one is that I don't know how to explain it, but you know, people tend to honor agreements a lot more when you go in front of a judge. In other words, when they've gone into the formalistic thing and they have a judgment, and more importantly, it's stronger. Let's say, right, believe it or not, a lot of, and now I'm talking to an all Anglo community, I believe, but a lot of Anglos unfortunately end up leaving. Okay, I think it's still something like 20 or 30%. So what happens if you go out of Israel? So let's say you've been married for 5 years, great opportunity, you decide to move to London or to New York, doesn't matter where, and you've been there for another 7 years, and then you decide to get divorced. Well, you had this prenup from in Israel from 12 years earlier. What's the status? Okay, so if you entered it in as a judgment, then in that new country, it's going to have a much stronger standing than just a prenup. Because then you can go, most countries have a law allowing you to take a foreign judgment and domesticate it. So you just take the foreign judgment, which is the prenup, and you domesticate it, and it's valid over there. If you want to argue, well, the prenup that we have, and you're in a different country, they can say, well, the first question was always, was it valid at the time it was executed over there? And then B, even if it was, some countries will say, was it also valid under our laws? And in the US, it'll be on the state law, right? And then it'll be, okay, well, is there any legal challenge for it? So I always say to people, look, spend the extra money and go get it affirmed as a judgment, and you'll be much more secure. And I do even more. What I usually tell people is, look, just like this is going to become one of those important documents that you put away, what you should do is you go and get it apostilled right away. I tell them how to apostille it and get it notary translated and then put it away. And the reason is because in every jurisdiction, if you want to domesticate it, that's what you need. And you don't have to start going 25 years in the case I gave, 20 years back and try to do these things to old documents. I'm sorry. Now, I'll address your question about Okay. So look, as parents, we want to make sure that our children are protected in case of divorce. And there are a number of ways that we can do it. First of all, let's look at real estate. I'm looking at real estate because most parents give the biggest gift, the big bang gift, when kids are buying a house. And what you can do there is either you can enter into a formal agreement, okay, and that says, hey, in the event of divorce, we're going to get our money back. Or you can say, in the event of sale of the apartment, we'll get our money back. And you can say, well, we'll loan it over into a new apartment. But you enter into a formal agreement with both the children and with the parent, and you can have that affirmed. That's one way. The other way is that when they register ownership, they can register a certain percent to the parent. In other words, let's say the parents are putting up 1 million shekels, the house costs 2.5, the kids have 500,000 and they're taking a mortgage for 1 million shekels, okay? So the parent can be registered for 40% ownership of the property. That's another way to do it. Now, you should also look at what is the parent getting back, because some parents just say, hey, we're giving the gift and God forbid they get divorced, we just want our money back so we can give it to our child again. Other parents say, well, you know, it should be as a percentage. In other words, if the house has gone up so that it's now worth double and I've given 40%, you know, then why should I only get 20% of the proceeds? I.e., going back to my last example, they bought it at 2.5 million shekels. The parents gave 1 million, and now they're selling it and it's 5 million. Well, if the parents are only getting their 1 million shekels back, they're getting 20%, even though they put in 40% of the original equity. Okay, so, and these are things that you should think about. In other words, you can do it either way. You can also do it as a flat interest rate. There are many ways you can do it. But the point is to have something in paper, not for something just to be given so that it can be construed as, hey, it was a gift. And we all know, as I said in the beginning, that gifts are considered things that were accumulated during the course of the marriage, and therefore they're split 50-50.
Would you suggest if, I don't know, couples married, the parents want to gift the kids a certain amount of money for an apartment? It sounds a little bit like, I don't know, unromantic, I think is the word we've been using, to be like, okay, kids, here's $1 million shekel, but you got to sign this document that if you get divorced, we get the money back, or the money only belongs to our child, or whatever. Would you suggest having, if someone is doing a document like that, because if they don't, what we're saying is the money is divided 50-50 between the couple. But if they are preparing a document like that, we put in like, if you get divorced within the first 5 years, then whatever afterwards, it's a gift, it's a loan for the first 5 years that belongs to our kid. But if you get divorced beyond that, we see the marriage is good and everything's fine, the money's yours. Would that work?
Absolutely, you could do that. I wouldn't suggest 5 years. I don't think that 5 years is enough.
Okay.
I think that when we look at the divorce rates, there are certain peaks. Okay, and one of the peaks starts after 7 years. So,
okay, so 10 years then,
hey,
not 5 years.
Why don't we wait 10 years? But absolutely you can do that. And I think that there's a lot of legitimacy in doing that. Or also they could do the conditioning just like the original prenup that we spoke about. That says, hey, for every, it's my interest as a parent that my children be in long-term stable relationships. And I'm willing to forgive a certain amount of the loan each year as long as they stay married. Okay.
Right. It's not the parents. I mean, parents hopefully think their kids are going to stay married and be happily married. But in that case, where like after a year, it's like the marriage is over. It's a lot of money that those parents would have lost out on. Okay. Next question. I did a lot of research and surveyed people a few years ago who were in financially abusive marriages. And each one of them told me that there were signs there from the beginning. They knew. They just they didn't realize how bad it was going to be. They kept telling themselves it was okay, and maybe their spouse got worse. But the signs were there from the beginning. And a lot of them, when I asked, like, why did you stay in the marriage so long or whatever, it's because they felt very stuck and they had zero access to money. So their spouse basically had taken away their rights to their own bank account, and they really had no access to money. And it's very scary to leave even a bad marriage when you have no money. So my question is, normally when it comes to joint accounts, I tell couples always have a joint account. You're in this together. This is long term. What you've been talking about is more like when it's large sums of money and gifts and whatever. When we're talking about the day-to-day accounts, my salary, his salary going in, do you agree with me? It should be one joint account. Is there any, if one's scared that their marriage isn't going in the right direction, is there any plus of having separate accounts or not?
Okay, so first of all, I think that there always can be a plus of having a separate account. In other words, my personal opinion is like yours. I say to people, look, especially if they're coming in and they're more or less even, I always say things get divided, however it works out. And we see a lot of cases where one spouse is in charge of money and one spouse is in charge of other things. Okay. And things develop that way. And whenever I come into cases, and by the way, it's generally the woman, but of financial abuse, who's being abused, right? Not who's abusing. What I do is I try to figure out, well, when did it start? Is it something that was from day one, or did it work into, gradually happen? And I always say it's like, for me, it's like Waze. Today, sometimes Waze takes me in these stupid ways to go things, and I still use Waze every day. And I ask myself, well, why'd you do that? But I've just become so accustomed to putting something in and going on autopilot that I don't evaluate and check, hey, is this really the right thing to do? And that's really what happens a lot of times in marriages. And I will say, one of the family law attorneys that I most respect in the country, and who's a good personal friend, and we were talking about a case that we had together. And I said to her, hey, your husband had an exit recently. He was the Mankal of a company. That is amazing. Why are you keeping on working? And she said to me, you know, Jay, the truth is, I don't need to work anymore. But I want to tell you something. Because of the last time we met when we were talking about pensions, I'm a big person on pension stuff. So she said, and I said to myself, wow, I don't even know what we have. And I said, oh my gosh, you know, this is someone who's incredibly respected in the family world, and you don't even know. And she said, Jay, I've got 4 kids, you know, that wasn't my interest. He always took care of money. I always took care of this. And I said, so do you identify with abuse spouses? And she said, Jay, I feel like you do, that, you know, we have to look at, hey, where did it start? So
Right.
I think what's really important is the moment you feel that it starts, and I would tell my kids the same thing. As a matter of fact, I do with one of my daughters in particular, is that, hey, if you ever feel that something's not going proper regarding money issues, first of all, tell me, let me be the jerk, okay? But second of all, start discussing on it, okay? Now, going back to your question, right? I've gone off on a tangent, but going back to your question. So I think that a young couple starting out, I think in all couples, I think that even when I have couples where one person comes in with a lot of money and the other one doesn't, I usually ask them, well, how do you view things? Do you think that from the day that you're married, you're one unit? And if you think that from that day you're one unit, then why aren't you guys willing to put all the new money, not old money, but new money from your salaries into that joint account? And again, I don't put it there as a judgment. I ask them, I want them to talk about it, okay? Because it might be that one is coming in thinking, hey, we're going to be like this, and the other one's coming in thinking, yeah, we're going to be like this, okay? As a matter of fact, the way that I really like that one of my friends explained it to me is he said, Jay, the issue is, how do you view the marriage? Do you view the marriage as 2 rings that sit one on top of the other? Or do you view the marriage as 2 rings that are connected, but they're not one unit? Okay, and that really is the question. I think that the answer to your question depends on how they view the marriage. I think the real problem is that people don't discuss this often enough. As a matter of fact, I just want to add one of the things that I'm always surprised about when I talk about the issues in prenups with people is I ask them, hey, have you guys talked about children? How many children do you want? And sometimes I get people saying, well, I want 2 and I want 6. I say, did you ever talk about it? No. I've had people say, oh, we just don't talk about it. I said,
Well,
okay.
right.
Okay.
This comes into what I call difficult money conversations. I did a talk a few weeks ago on enduring power of attorney, where also that comes into a lot of difficult money conversations. This talk also, it comes into, it's a difficult money conversation. There are a few things in place that sort of make it easier. I think one of them is a little bit of humor sometimes. 2 is talking about it not as the unromantic way, but more, let's protect each other. 3, having that in place, that like, this is just for the beginning, like, you know, that after 10 years or 20 years, these things are irrelevant. We're joint, we're a couple, we're together in this. I have a lot in my course on couples and marriage about just talking about all these things that people don't realize, just like you said, about little kids, but people don't realize they need to talk about their money personalities, what they think financially. And then we'll bringing us to the next important topic that I want to discuss with you is inheritances. So like you mentioned before, like if someone isn't expecting an inheritance, not everyone knows when they're expecting an inheritance, meaning I've met plenty of people who've come to me and like been like, I just inherited 10 million. I had no idea my parents even had money. You know, so these things happen. People don't always know what they're going to inherit. So it's sort of this hypothetical question that I sometimes ask people, like, if you were to inherit money, you know, how do you see it? Does it belong to both of you? Does it not? But my question to you about inheritances, I'd like to hear, you know, what's the law? I presume it's the 50-50, is what if a parent decides that they don't want, I don't know, they don't like their son-in-law. They want specifically their daughter to inherit. Can they write it on the will that it's the daughter's money, even if the couple don't have some agreement between them?
Okay. they can. The problem with that is that the day after, the daughter can say, okay, I know that's what mom and dad wanted. Let's buy a house together. Okay, or let's put it in jointly anyway. And the way to go around that is really to either to put the money into a trust or to give a trustee the right to dole out the money as he or she sees fit. Okay, and that's, the truth is that with regards to the gifts, it's also a problem that I've seen is that when people have given money conditionally, but they didn't anchor it properly. When I say anchor it properly, they did it with a letter or something, they didn't get it affirmed as a judgment, they didn't register something in the taboo. Then one day the child decides, yeah, I know what mom and dad wanted or said, but I love you so much, or I feel so indebted to you, or whatever it is, that we're going to disregard what we originally said we were going to do. And that's really part of the reason that I say get a formal agreement, get it affirmed in the court, and get something registered in taboo.
But sometimes something like that could be a solution, meaning you're saying, I know I leave money for my kids, will pass away at 120, my kids get money. If they're happy in their marriage, then they could share it, but I've left it for them just in case they needed the money themselves.
Well, what I tell every person, so let's look at what the law says, okay?
Yeah.
Inheritances in general, if it's kept in someone's personal name and isn't commingled with the rest of the, we'll call it community property, okay, another joint property, then it stays that person. So let's look again at a case, okay? We have H and W, husband and wife, and W inherits $1 million from the parents, and W keeps it separate. It's in a fidelity account, and she's just getting checks every quarter for a certain amount of money, but she never retitles it, and she never uses the money for anything that goes together with H. It's always W's, and she may say to H, don't worry about anything. We always have my parents' money, okay? But at the end of the day, she doesn't retitle it there. So H will have a position in court to say, well, she always told me that it was mine, and I thought it was mine. And the court may look and say, well, what was the intent? Okay. If we think the intent was that it be his, then we may say that we get or some of it, although it's a very weak case. That being said, I do want to tell people about a case that I didn't represent on, I just followed. I thought it was fascinating a couple of years ago. It was a mother who lived in a moshav, and they had a zchuyot binyan, rights to build. And what she did is she said to her daughter, who was married, she said, why don't you guys build a house over here? And you know what? I have the money and I'm going to build the house. Okay, I'll give you the money to build, but I want you to live next to me. And the couple went through, they built the house. They then had, it's called the Ben Mamshich, continued child on the moshav. And bam, they get divorced. And the real pity was they got divorced about a year after they finished building. And the husband said, but they always said it was for both of us. And the court looked, and then here's the thing, I want everyone to pay attention because this is the important part. So the court said, wait a second, in the, how do you say, testimony, okay, also of the mother, also of the wife, they said the husband, who's an engineer, was there every single day, making sure that everything was done properly, making sure that it was, and the judge said, so clearly, at least from his understanding, the intent was that it would be his also. Otherwise, he wouldn't have done that. He wouldn't have spent that much time and effort. And because no one said to him, no, it's not yours, don't go doing this, clearly it was their intent also. Okay, and then the judge said, however, I don't think it's fair that we have half of it. So what I'm going to do is I'm going to take the value of the land and I'm going to subtract it and say that, well, they probably never intended to give him the land, okay? But they did intend to give him the house, and then they gave him 20% of the value of the house on the land, saying that, that's the value of what he thought he would be getting. It's a stupid ruling in terms of the percentage, okay?
Right.
But it lets us see, it's a really good example of how the judges will go back and say, well, what was the intent? Okay, and that's why I always tell people when they get inheritances, if you want to share it, God bless you. But if you have any doubt that you don't want to share it, either enter into a financial agreement, even in the middle of marriage, with your spouse, okay, and or keep it separate. And understand that the fruit, the dividends we talked about, will be eaten. It'll be both of yours.
So there's a real key issue here, it sounds like, that if I inherit money, don't want my husband to have access to it. If I put it in my joint account, it's ours, and we get divorced the next day, it's 50-50. But if I were to put it in an account that's just mine, let's just say investment portfolio, and I reach out to an investment manager, and I have it managed, and I'm in charge of it, and there's no joint anything about it, and chas v'shalom, we were to get divorced, that is my money. Is that correct?
That is correct. And I want to give you guys another example of a case that I'm litigating right now, okay? So this is an Israeli woman who's married to an American. They lived in America for a long time, and they came back about 8 years ago. And now, unfortunately, they're getting divorced. When I was going through all of the paperwork from all the banks during the years, I saw that there was one time when the husband got an inheritance of $1.4 million, and it went into their joint account for one day. It went in, probably, and I'm not sure, because the person who ran the estate put it in the wrong place. Went into their joint account, went out. And this is a classic case, by the way. The woman has no clue about their finances. She just knows that all the years, she gave whatever money she made to her husband, and whenever she needed money, he gave her money. They're a mildly affluent couple. And I went into the court and I said, look, from her point of view, all the years she thought everything was joint because she just put it in and he gave it to her. But even more, I can show that this $1.4 million went into the joint account before it went back out into it. And he's arguing, no, that was a mistake, it was a mistake. And I said, no, that shows intent. And the judge said to us, I'm not ruling on this right now. What I suggest is that you work out some type of compromise. Because if I have to go through the whole trial and I do establish intent, then one of you is going to pay big time, especially with the new rules allowing us to give fines for legal fees to the other side. So I suggest that you really do think of something that's a little bit more fair than both of your sides of, hey, I'm entitled to 50% and yours of I'm entitled to 0. So.
Okay, that's very interesting, and it's good for people to know.
Yeah.
Very interesting. Okay, so just to summarize this part, joint bank accounts, day-to-day finances, sounds like it's really fine, because if people do get divorced, that's going to split anyway. If people get gifts or inheritance, and we're talking about big gifts, not like if they get 1,000 shekel, I imagine, like we're talking about big gifts, and they put it, and for whatever reason they don't want to share it, they put it in an account with their name, and it never touches a joint account. It's probably going to be seen as theirs, though it sounds like there are cases where, there are questions about that, like your example before, and that's how we deal with gifts and inheritances. I just want you to take one moment to explain the inheritance law if somebody doesn't have a will. Who inherits? Does it belong to both spouses, etc.? If you just take one moment on that, that would be helpful for people.
Sure. The base rule is that half of your assets go to your spouse and half gets divided equally between your children, okay? So I just wanna look at this because it's important. A lot of people don't realize it. When you come from Anglo-Saxon countries, right, then we usually have something that's known as tenancy in the entirety, i.e. we buy a house, I'm from New Jersey. So we buy a house in New Jersey and both of us own 100%. And if spouse 1 dies, spouse 2 just owns the house, okay? Well, here in Israel, the base is that each spouse owns 50%, okay? So we buy our apartment in Manana, spouse 1 owns 50% and spouse 2 owns 50%. They don't do any estate planning, don't have a will, spouse 2 passes away. Well, at that point, spouse 1 owns 75% of the house, right? With half of the 50% that the spouse that passed away had, and the children own 25% of the house. By the way, you don't know how much litigation there is in Israel over estates where you have all of a sudden, I had a case in Jerusalem where nobody ever did wills, And there were 16 people because grandma and grandpa passed away. Nobody probated the estate. And they had 3 kids. The kids have all since passed away. And now I have all these grandchildren who are fighting over the amount. And I just want to sell the property and be done with it. And we can't because there's so many court issues involved because nobody ever did anything. And on that note, I want to tell one more quick story just so that you get the idea of what can happen. I have a very wealthy couple where I did the will for, and I'm now doing the estate for the wife. When I started probating the estate, I found out that the husband had passed away 20 years before, and they never probated the estate. Where is this a problem? This is a problem because I have a $4.5 million house that I can't sell. Okay, because I have to now go through and do a 20-year-old estate. They don't have any children, so it really would have gone only to the wife. But now everyone gets involved because in Israel, when you start the proceedings, they say, well, okay, we want to hear what the government attorney says about this case. We want to see. And so now I'm, a year and a half into this nightmare state because the wife who I represented 20 years ago hadn't done the probate from her husband.
Wow. Wow. Okay. Wills is another talk, another time. People watch out. It's something that I have planned to talk about. This is the last question for now, and then we need to wrap up and we're going to take people's questions. I saw in the chat a few people have already asked. So the last thing I'd like to ask you, Jay, is you said to remind you to talk about Heskem Kavod Hadadi, what that is, when it's needed, and then we'll move to people's questions.
Okay. So Heskem Kavod Hadadi, and I say it so that everyone knows it's not something that I created, but it's something that I ripped off. I copied from Sohar. I think Sohar has done an incredible job making this available to everybody, and this is why. And I tell all of you, if your kids are getting married, you can send them to me. I will send them a copy of the Heskem Kavod Hadadi. And what it really is it's a tool to prevent aginut, or literally being chained, or people who can't get divorced. See, in Israel, since all divorces between 2 Jewish spouses is done via the rabbinut, and this is even for people who got married civilly outside of Israel. Okay, in other words, 2 Jews get married in Cyprus because they don't want to go through the rabbinut, but when they get divorced, they're going to have to go through the rabbinut. In any case, so the Heskem Kavod Hadadi is basically an agreement that says, hey, we all know that you can't force someone to give a get or to get a get, okay? And we all know that it's a bigger problem for women. The reason is that if a woman doesn't have a get, if she has another relationship, it's considered adultery, and any children born to that new marriage or new relationship will be mamzerim, according to halacha, which has a lot of legal ramifications for the children later on in their lives. So what can we do? We also know that there's a problem. You can't force someone to accept the get or to give the get. So the Heskem Kavod Hadadi is a tool that works like this. It says, hey, if either of us want to get divorced, then from that day, from the day we give notice to the other party, each of us is going to have to pay support to the other spouse. So let's take, again, the H and wife scenario. Husband and wife have this Heskem Kavod Hadadi, and it says that if either of them want to get divorced, each of them is going to have to pay a monthly support amount of 10,000 shekels to the other, right? Which really means nothing passes. It means husband is giving the wife 10,000 shekels, the wife is giving the husband 10,000 shekels. Okay. Now the second part of it says, but if one of us is unwilling to accept get or to give the get, right, then the party that is unwilling to move forward still has to keep paying the monthly support amount, but the other party doesn't pay anymore. Okay, so that at the end of the day, let's say husband says, well, I'm not willing to participate in the rabbinic hearings and I'm not willing to give the get. Well, then husband will have to continue making the payments of 10,000 shekels a month. Wife doesn't have to make the payments. And the idea is that husband's going to say, wow, is it worth 120,000 shekels a year for me, plus anything else, because we can still be sued for other things, not to give this person a get, or am I better off giving the get and moving on?
Right. Very smart. Very smart. Okay, so we're going to wrap up this part, and now we're going to open up for questions. I see some people have written questions. So Jay, I'm going to just ask you the questions that they're asked. Someone's asking, if the parents keep a percentage of the ownership of an apartment, it was one of your suggestions when parents are gifting that they write their name on the ownership. Does that make it difficult to sell? Do the couple need permission to sell? If the parents pass away, what happens? Does that percentage then go to whoever's on the will? How does that happen, and how's that dealt with?
I want to say yes to all of the above, but I'll go through it. Okay, so first of all, right, obviously the apartment can't be sold if the parents don't agree to it. Okay, in that situation, in other words, if they're registered as a 33% owner. But they can enter into an agreement when they do this, that if the children want to sell, that the parents will agree to have their interest transferred to a new house or new apartment. That's one of the things they can do. They can also say that if it gets sold, that at that point in time, they'll get their money back. Okay, again, I don't say that anything is easy, but I do say that it's a way to ensure that your kids are going to get what you intended them to have. Now, regarding the will, it should be addressed. As a matter of fact, there are certain life-altering events that I always tell people, listen, redo your will at this time. You know, it's the birth of children when it's a young couple. Sometimes it's the birth of grandchildren or special needs children down the line. I tell people, look, redo your wills when you have that type of event, God forbid. And the same thing, if you're giving a big gift, depending on how you're registering it, you want to redo your wills to address that. I would say even more, that anytime you make a major financial change, it's always worthwhile to at least look at your current will to see if it covers it. In other words, I always use a catch-all clause. I'll allocate specific assets in specific ways in the wills when people want it. In other words, couple comes to me, they have their house, they're upper middle class, they also have 2 other apartments, they've got 4 kids, and they start by saying, okay, what we want is we want all of our assets to be split equally amongst the children. And then a couple of years later, one of the children has a special needs child, and they say, well, we really want to give her a bigger portion. So then we'll look at the houses and we'll say, okay, then maybe it shouldn't be just everything gets split equally. She's going to get a little bit more from house A. Maybe she has a right to live in house A rent-free until the kid gets 21. Whatever it is.
Right.
But the point is, anytime something like that happens, or now they buy a new house, the 4th house at this point, look in your wills. Maybe it's time to adjust it. Check out what it says regarding this new asset.
Okay. It sounds to me like that idea of putting the parents on the apartment, I don't think would go down well for most kids anyway. And it sounds like it's really complicated if they were to pass away, and then what's on their will and whatever. Meaning it sounds like one of the other methods, if the parents want to protect their money in case of their kids getting divorced, one of the other methods you mentioned would be a smarter way to do it rather than that.
Well,
Okay.
I think it would be cleaner. And
Yeah.
The other thing that I suggest is just putting in a lien. In other words, they can put a lien against the house for the amount. And then if the kids want to sell, if the parents want to roll over the lien to the new house, just like we roll over mortgages, they can. And if they won't, the kids will have to pay off the lien before they move forward.
Okay, I have a couple of anonymous questions. I'm not sure sounds very specific. I'm not sure it's something you can answer. Widowed father of grown kids. The father's new girlfriend wants to relinquish the inheritance received from their deceased mom and give it back later in her will. The kids are refusing. Do the kids have legal rights? Or does this girlfriend even have legal right to ask for such a thing?
Well, so we can always relinquish our interest in a will. In other words, if the father left the will to another, we're talking about, first of all, the right to relinquish comes up after the father's passed away. If the father's still alive, then the woman, the new girlfriend can change her mind any day. That's number one. Number two is at the time of relinquishment, or at the time that the father's passed away and the will starts to be probated, at that point in time, she can say, I relinquish my interest in the father's estate in favor of the children, and that will be honored. If the children then don't want to accept it, that becomes a question of, well, then who inherits, and that actually is going to be the case of litigation.
Right,
Okay?
right. Okay,
And
that's
the
what I
reason
figured you'd
is because
say.
the state wants their interest too. You know, the state can say, hey, we want it. And when you will go through the probate, the court is going to say, okay, I want to hear what the Lloyd Summon shall be has to say about it.
Right. Okay, someone's asking if I inherited a stock portfolio, put it in a joint account just because that was the only account I had, and now I want to reiterate and put it in my own account so that it's really only mine, but my husband doesn't want me to do that. Can I do that? If we were to get divorced, what would the courts say or see?
First of all, you know, you can unilaterally do whatever you want. I don't know if it's going to include the marital relationship. Let's start by saying that. But beyond that, I would say that the court will look back and say, what was the intent? So have you held it there for 4 years? If you held it there for 4 years, then there's a lot more chance that the court is going to say, yeah, the intent was that it be joint than if you had it, like in the case I told you about, 1 day. And you see, even with 1 day, the court is willing to entertain. You know, I know that if I go all the way through, I'm going to lose, okay? Because I don't think that showed anything. I think the judge will give me something. I think the judge will do a different workaround and give me an unequal distribution of assets, which they're allowed to do, but he won't link it directly to that 1 day, okay? On the other hand, because I've got that 1 day, they're considering it, at least telling us, hey, based on this, you got to start negotiations. I would say to you, to that person who asked the question, negotiate, you know, say to your spouse, do you think it's really fair? Right now we have a rocky marriage, and when I inherited it, we still had a rocky marriage, but because of my faith to the marriage, I put it all in. So you know what? Let's talk about this. Do you think it's fair that you get 50%? Maybe, you know what? I'll leave you 10%. I'll leave you 15%. And then get it into a formal agreement, get it affirmed as a judgment so it can't be challenged later, and then do the move of whatever it is.
Right. And thank you, Jay, for your answers. This is definitely a fascinating topic and also a very, very important topic.